Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Your name?
Joshua Bertram.
Thank you.
See you, Judge.
Good seeing you, sir.
We come to an agreement on this one also. The amount of rent that's owed is $245, court costs of $175 for a total of $420. Mr. Bertram says he can pay that by Monday. I gave him obviously till the 9th. And I was thinking that because the amount is relatively low, we should put under further orders, no writ without a hearing. Have I caught on now?
Yes, you
Finally.
All right.
So what that means is that if for some reason you don't pay, and if I file an order of eviction, the court would set that for a hearing. So
Yeah, may I say something?
Certainly.
I get paid basically twice a month,
Okay.
and it's been we're in our slow season right now.
Joshua Bertram appears in court owing just $420. He explains work has slowed down at his printing company during the off-season. The judge approves a consent judgment and adds no writ without a hearing, giving him breathing room to catch up.
So my check has not been like half of what it used to be. So I'm just trying to make do with what I can, and that's how I fell behind. So I do apologize. I don't mean to be back in here.
No, it's okay. Quite frankly, young man, that happens to a lot of folks. And I think what's fortunate about being in this county is that a lot of the attorneys, a lot of the judges appreciate that's what happens to people. And it's really just a matter of catching up, getting yourself kind of a little bit ahead so that happens.
I'm trying my hardest, sir.
No, I got you. So your slow season, when will it pick up? Like April?
I think March, April.
Okay.
When March Madness starts to begin. I work for a printing company, Underground Printing. So after like Amazon orders are done with through December, like the end of December, we start slowing down through July, February, and March.
Got it.
And then once the school season starts again,
then you pick back up
work. So
do they order any like Maryland gear to print?
Maryland?
Don't say confused.
just say yes.
Don't look confused.
Yes. Yeah. No, we print.
It's like
we print all of them. Yes.
Anything with it.
What'd you tell him? Just say yes. Just say yes.
University of Michigan, MSU. We do Iowa.
MSU. That's like Spartans.
Yeah, that is.
Yeah.
We do everything.
That'd be easy to print. Anyway.
You guys want?
All right. Okay, sir. So you have no questions on this judgment. I'm going to enter the judgment by consent. All right. And so if it doesn't pick up right away and you're back, you're back. We'll get you through it. Okay.
I dealt with Mr. Bertram before. He's always easy to deal with, and we always work something out.
Yeah. And just getting there. So
just getting there.
Just getting there. All right. You take care of yourself, young man.
Thank you.
All right.
Thank you, Mr. Bertram.
Where? Why?
But the next case shifts the tone. A landlord's attorney requests dismissal after a family emergency prevented notice from being sent earlier. Defense counsel argues his client shouldn't have been dragged back to court at all.
Why is she in Zoom? Oh, she's someplace else. What? She said she's not coming here to see me. She wouldn't make it in time.
We did start at 12.
Did she know she didn't? She knew she had 12. Why?
That's a question.
Where is she? Do you know where she is?
Detroit.
Did she tell? She's in Detroit?
Yes.
That's a big place.
It is a big place.
That's all for me at 12. I'm covering.
You're going to cover at what?
Yeah,
right?
for Sydney. Yes.
Okay. All right.
So I'll see you in an hour. Thanks.
All right. Thank you, sir. Arbor Meadows versus Akio Fujimaki.
Good afternoon, Your Honor. Gabriel ACP 79685 for the plaintiff, Arbor Meadows.
Did you hear us talking about you?
Yes, Your Honor, and I do appreciate you allowing me to appear via Zoom.
You're more than welcome. All right, Mr. Stringer.
Yes, Your Honor. Thomas Stringer appearing on behalf of Akio Fujimaki.
All right. I have a dismissal.
So, Your Honor, if you could allow me this time to address Brother Counsel, I had a family emergency, and I do apologize. I did not get to reach out to you and let you know that we were dismissing this case. And we will not be bringing up the other cases.
You have any objection to that?
Well, I have no objection to it being dismissed. My client did want me to ask for fees. You reserved them. I've had to come back again. When I look at I looked at my time after today, I'll have between $1,200 and $1,500 into this. It's unfortunate that my client gets charged for that.
Yeah, I will
Have
state that,
anything to say to that?
yes, Your Honor. I will state that, this could have been resolved, if he had just paid the court costs with notice. And my client was willing to do that and waive the late fee. I was willing to be very amenable, and at this point, decided to just do a courtesy fee waiver for the court cost. And I do not believe that fees should be attributed to my client, as my client's just trying to assert their rights as a property owner and keep the place where he calls home beautiful.
Yeah, but remind me, were the court fees due?
There were court fees, but the issue was Your Honor did not specifically award them in the
Correct.
last case. That's what it was.
Right, but that's part of the problem. And Ms. Lacy, I appreciate that you, at Emergency Counsel, has been out here twice, and I was extremely skeptical of the argument that was being made at the last hearing, because everything was settled. And quite frankly,
The judge makes it clear someone from the firm could have filed a dismissal. He says the case likely lacked merit from the start and that the defense attorney should not have had to spend time and money returning to court.
I don't know that Arbor Meadows should have been coming after him for something that wasn't contained in the written agreement or judgment between the parties. And that was part of my problem. And now we are back here again. And
Well, and I appreciate counsel having some family issue, but somebody from the firm could have sent me a dismissal, and at least I wouldn't have had to come out here today. And that's what's inherently wrong about this. And I'm not blaming counsel, but obviously she works for a firm who decided to file this. And really, there was no merit to filing this. And saying that Mr. Fujimaki could have paid the fees, well, he wasn't ordered to pay the fees, and we never agreed to pay the fees. So this is just wrong. I'll leave this up to the court.
Ms. Lacy, I get the family emergency. I get all of that, and you kept the court apprised that you weren't going to be able to be here today. I wasn't sure what was happening on the case. So that I think all of us that have been in practice realize stuff happens, right? Okay, so I get that. I appreciate, though, what Mr. Stringer's saying, that somebody could have sent that. I am also, how do I want to say this? I'll put it this way. Sometimes people are sent in to give arguments that may themselves not have a whole lot of merit, and they have to just go about doing their job. And I can appreciate that. And I don't fault attorneys when they're placed in that position. I may be wrong, but I think, Ms. Lacy, you always give very good, cogent arguments grounded legally before this court. I felt, well, I'm just going to say it, and I don't know if I'm right, but I think that if it were up to you, we wouldn't have been here last time arguing. I think somebody has put you in that position, and unfairly so. I say what I think. I think you were put in that position unfairly. I don't think you would have given me that argument because that's not what you do. But Mr. Stringer and his client should also not be. So I'm not going to award the 1,500 or whatever it would be, the 15. I will award $500 in attorney fees that will need to be paid by, I'm going to say is that it needs to be paid by the plaintiff to the defendant's attorney.
By, we have a time frame, Your Honor? 2 weeks, a month?
Yeah.
Whatever the.
Pay it by March 16th, 2026. All right.
And I just want to put something on the record that I've had my assistant check every day for the last few days to see if we were receiving anything.
Right.
Because originally she was going to, and I'm just not blaming her, going to file a brief or file an amendment to request an amendment. So there was just nothing ever, and the dismissal could have come. I mean, from somebody.
And I'll say this, and I'm not here to defend Miss Lacy. I'll just say this. Hey, if she could have, she would have. I have no doubt in my mind. And I think that there may have been outside things hampering her. So I don't hold her responsible. That's why I phrased it the way that I do. I don't think that comes, I don't know whose pocket it comes out of. I'll make this clear in my mind. It should not come out of Miss Lacy's pocket. Whoever did what they did, that's who should be paying. I don't think she would have done this. She's never done that in the years that she's been practicing.
I fully accept that. I have no ill will at all.
I know you don't. So, and it's a good thing that this is the attorney on the other side, because this could have gotten real ugly. So, all right.
Probably true.
Yes. Thank you.
Thank you.
And Ms. Lee, I'll say this. Mr. Stringer doesn't come out here that often. He used to come see me all the time. Now it's every once in a while, here, there. So the very fact that it didn't get to him and I got to see him again, I'm okay with it.
Mr. Stringer, my sincerest apologies, and I do thank you, Your Honor.
Well, and I appreciate that. And again, there's no ill will whatsoever. I think you're a fine attorney. Just things happen.
Things happen. All right. Thank you.
Thank you.
$600.
500.
No. $600 from Ava Meadows to requested me is usually gone. $600 is
That's in the other case.
that is stated.
Oh, yeah, no. This case is being dismissed.
This case is being dismissed.
That's what he's asking about, the $600 that they requested.
Yeah. Okay. All right. Thank you.
Thank you, Your Honor.
Field Properties versus Matana Patrick.
Gabriel Lacey for Bill Properties.
Not checked in.
They have not checked in. Would you like to take a default?
I would, Your Honor.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go
At
ahead.
this time, Your Honor, we are requesting a default judgment for possession only, where the outstanding balance to pay is $1,918.36, court cost of $175. Total balance owed is $2,093.36. We are asking for a pay or vacate date of March 9th, 2026, and I do attest to the best of my knowledge and belief that the defendant is over the age of 18, competent adult, not deployed on active duty in the military, and we have kept the unit fit for habitability.
Instead of awarding the full $1,500 requested, the judge orders $500 in attorney fees to be paid by the plaintiff's side, not the individual attorney. Accountability matters in this courtroom, and unnecessary filings come with consequences.
Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested. The writ to issue 10 days. All right.
Thank you so
Thank
much,
you.
Your Honor. Have a wonderful
Thank
afternoon.
you.
Thank you to you and your staff.
You have a good weekend.
Thank you.